Well, hello, John. Thanks for uh, thanks for putting this together. I see a couple of the folks here in the audience. I see we have an attorney in the audience, a very good friend, David Ansani, and Cole. I think you and I may have spoken on your podcast before.
Yep.
So, welcome. That's great. All right. Well, everyone thinks that because cannabis has become legal and recreationally legal in the state of Illinois. Of course, it started earlier with the medicinal use and the Compassionate Use Act, et cetera. But now, since 2000, it has become legal for recreational use. So I want to go over some of the laws that affect people who want to partake of recreational marijuana, cannabis, and how they can not only possess the cannabis legally, but also transport it. And there are some things that people should know so that they don't run afoul of the current law in Illinois. And so let me begin. Let's get this share screen going.
Bob, just to let you know, we're welcoming Lee Nielsen to the group.
Well, hello, Lee. Thanks for
Hey, Bob.
joining. Thank you for joining us. All right, so and let me. All right, how's that? Can everybody see my presentation okay now?
Yes, sir.
All right, so possessing and transporting cannabis in Illinois legally. So just because recreational cannabis is now legal, it doesn't mean you can have as much as you want. It doesn't mean you can possess pounds of cannabis. It doesn't mean you can go out there and walk out of your house and start smoking a joint as you're walking down the street. I mean, you can do that, and it's possible that you could be in violation of the law and could get arrested. So these are ways to try to avoid that, because it may not be the small time use of marijuana that you want to avoid. It may be other things that it could lead to, other searches that are incident to that kind of arrest. So let me begin first by talking about, there are, of course, two different kinds of status that you can have in terms of cannabis use in Illinois. One is through the Compassionate Use of Medical Cannabis Program Act, which went into effect earlier. It was sort of they gave it a trial run for a few years, but formally it was enacted in August of 2019. And the Cannabis Compassionate Use of Medical Cannabis Program Act was at one time very restrictive on the kinds of conditions that would qualify as conditions that would, let you get one of those medical cards. And since the list first came out, it's become a little bit more relaxed, and there are more conditions that are available. Recreational marijuana, on the other hand, is controlled under the Cannabis Regulation and Tax Act, and that's the one that went into effect on January 1st of 2020. So here we have the recreational cannabis use beginning, and it coincided basically with the beginning of the pandemic. There are, needless to say, in the state of Illinois, it has generated a large revenue stream that seems to be getting bigger almost every month. So where are you not allowed to possess or use marijuana? Well, the first one, of course, lawmakers are always concerned about children and being impressionable. And so schools and buses, you're not allowed to have cannabis. There are cannabis trained dogs, and a lot of times people think, well, what's going to happen to these cannabis detection dogs, the ones that have been imprinted to smell out drugs like cannabis? Now, because of legalization, they'll be useless. No, they're actually you can still use them, because there are places where cannabis is not sanctioned and allowed. Among them schools, or buses. And also, think about it, prisons, you're not allowed to have anything like cannabis in a prison. So, I mean, places like that will still allow you, will still be places that you are not allowed to have cannabis. There is an exception, and that's this Ashley's law, and that allows medical cannabis infused products under the supervision of a nurse and administrator. So that's the situation where you have children who have seizure disorder or some other kind of ailments, and doctors that cannabis as therapy for that. And when that has been allowed or that has been prescribed, then it can be, but you're not going to have, junior smoking anything inside the school or vaping anything. It has to be into an infused product. So essentially, it's given sort of like on a medicine dropper. Prisons and jails, as I mentioned, cannabis is not going to be allowed there. In private vehicles, it's not allowed. It's not allowed in your car unless it's in a reasonably secured, sealed container and reasonably inaccessible while the vehicle is moving. That's a whole lot of stuff going on there. So basically, in Illinois law, what it says is that if you're carrying cannabis, I have to learn to use the word cannabis as opposed to marijuana. But if you're carrying cannabis in a vehicle, it has to be reasonably secured, sealed container, and reasonably inaccessible while the vehicle is moving. That's under the Cannabis Control Act. We'll see later there's a provision that also requires it to be in an odorless container. And that's under the Illinois Vehicle Code. Cannabis also is not allowed at a daycare. So if you're running some sort of home daycare, you can't have cannabis on the premises. So not only daycares that are off-site and close down after 5 p.m., but also ones that are in homes where you've got a lot of residential home daycare providers who will have their basement, and they'll use that as a daycare for children after school, etc. And it's a licensed program, etc. But you are not allowed to have cannabis there. You also are not allowed to use cannabis in a public place. And it's interesting that the public place definition does not include hospitals, nursing homes, hospice care centers, and long-term care facilities. And I suppose it would be contrary to common, it would be counterintuitive to say, well, we're providing medical cannabis, but you can't use it in a hospital. So I suppose that's why they carved out that exception. Being recorded. So that's why I imagine they carved out that exception, although I'll be honest, I have not read the legislative history to the extent there is any regarding that. You may not also use cannabis around people under the age of 18. That's also in the law. So let's talk a little bit about medical cannabis. Medical cannabis, you have to apply for a medical card. There, like I said, there are a lot of different conditions that are now allowed, but before Illinois had one of the most restrictive sets of conditions available to get a medical marijuana card, a cannabis card. Smokable medical cannabis is not allowed for patients under 18. So as I mentioned, it has to be in an infused product form, probably like a tincture or something, when children are taking it for their seizure disorder, etc., their epilepsy, whatever condition they may have been prescribed cannabis as a therapy. Opiate alternative programs available. So some programs use cannabis as a therapy to provide an alternative to people who are using opioids as pain relief. So chronic pain, things like that, that's usually something that's right up medical cannabis's alley. Interesting thing about the medical card is you can actually designate an individual, a caregiver, who can go to the store, the dispensary, and obtain the cannabis for you. So let's say you're, in hospice, you're in your advanced years, you don't really have the ability or the mobility to get in and go drive to a dispensary and purchase cannabis. Well, you can designate a caregiver, obviously an adult, who can go to the dispensary on your behalf and obtain cannabis. Um, Another thing is, manufacture of cannabis, meaning growing the plant, is not allowed recreationally. Civilians are not allowed to grow cannabis unless they have a medical card. And if they have a medical card and they have a green thumb and, put some effort into it and some knowledge, they can grow up to 5 plants for home use. That is allowed. So the only time in Illinois where, unless you have a grower's license and are involved in the, in the industry, you can only grow cannabis in Illinois if you have a medical card. And how much can you get? Well, if you're a medical card holder, quite a bit. You can purchase 2.5 ounces. That's 71 grams every 2 weeks, every 14 days. Now, one thing interesting is that unlike recreational cannabis in Illinois, medical cannabis, actually, they do keep track of. There is a tracking system. So if you're purchasing 2.5 ounces within 10 days, for example, it will red flag. The system should be able to indicate this person already got it. They have to wait another 4 days. Kind of like when you go to your pharmacy and you have a prescription and you can't refill it before the 30-day prescription is up. So it's a similar kind of thing with the tracking system that's been allowed for medical cannabis use. Recreational, the rules are a little bit different, as I said, but you have to be 21 years of age. If you're a resident of Illinois, you can possess up to 30 grams of flower at a time, or up to 500 milligrams of a THC infused product, or 5 grams of cannabis concentrate, or half of all of those things if you're a non-resident. So if you're in from Wisconsin and you're 21 and over, you could then go up to a dispensary and purchase you could purchase 15 grams of flour, or 2.5 grams of concentrate, or 250 milligrams of THC. So those are the basic differences between the two types. So I've got this little list of do's and don'ts, and I want to kind of go over them. Some of them some of them probably are fairly straightforward, right? So let's go over the do list. These are the things you should do. One, I think it's good to keep the product in its original packaging. And if you have a trunk of a vehicle, it's a good idea to put it in the trunk. To the extent that you can control odor, it helps keep the odor away from the passenger compartment. If it's in its original packaging, it kind of has the provenance to show that you've legally purchased it. Not that it's requirement that you prove that you purchased it from a dispensary if it's just on the basis of possession. And what I mean by that is, if you're 21 and over and you're a citizen of Illinois and you have, let's say, 25 grams of cannabis, obviously you're allowed to have it. They're not going to ask you where you got it from. They don't have a right to know that. There's no requirement that at all times it show the original packaging, but I think it helps. It's also a good idea to operate your vehicle lawfully. Do not give police a reason to pull you over. Obviously, that it means no speeding, weaving, no traffic kind of violations. But it's probably a good idea to maintain your vehicle and make sure that things that will lead to a traffic stop that seem innocuous but can snowball, like having a tail light that's broken or having a cracked windshield or something like that. So it's usually a good idea to operate a vehicle that's in good condition and not in not having issues which will call attention to the police to pull you over. When you do make that purchase, wait and get home to enjoy your purchase. Try not to use the product in your vehicle. It's never a good idea to use cannabis in a vehicle in Illinois. It's not going to be that's not usually going to lead to a good outcome. So um, it's just not a good idea to have cannabis in a vehicle and use it. Also, you should possess a legal amount. Don't have more than what you're allowed to possess. Given your status, your whether you're from Illinois or from out of Illinois, and of course you have to be 21 years at least. Now, I did put a little thing in here about possess a legal amount, even though nobody will check on you purchasing every day. So, unlike the medical card with recreational cannabis, um, the statute, the Cannabis Control Act, has built into it certain confidentiality and privacy measures for purchasers. So, no. While they're required to keep a very good inventory of what's being sold and when it was sold, they are not allowed to keep a record of the name or any information about the purchaser. So, what does that mean in effect? It basically means that under the law in Illinois, you could purchase 30 grams one day, walk back there the next day, purchase another 30 grams, and you could do that continuously for 30 days. So theoretically, you could have 900 grams without them ever batting an eye about you coming in and purchasing it every day. The problem is, if you ever are stopped with more than 30 grams, that's going to cause a problem. And we'll go into what level offenses those are later on. I'll get to that as well. So these are the things that you should not do, right? Don't use the product while you're in your vehicle. It's a Class A misdemeanor. And if you do it with a medical card, you lose it for 2 years. So it's a fairly severe sanction. Don't travel across state lines with cannabis. It's illegal in many states, but it also violates various aspects of federal law by crossing state lines with it. So if you're going into Indiana, that's probably problematic. And even though it's legal in Michigan, you can't get to Michigan, last time I checked, without going through Indiana or going through Wisconsin, 2 states where it's illegal. Don't take it with you on the airplane. I think I'm not trying to advise people on let's put it this way. There are reasons why they have amnesty boxes at O'Hare Airport and at Midway Airport. I don't know if you know what those are. Those are those large boxes where you can drop off your weed, because when you're traveling on an airplane, that's controlled by federal law, and it's still a violation of federal law to have cannabis. So it's always a good idea not to take this stuff with you. Hopefully travel to a place where they have it so you can continue if you want. Also, store the product in the passenger compartment of your vehicle. Don't do that. It's not a good idea. The leading case is a very old case called New York versus Belton. And basically, while it allows sometimes for a search of the interior of the vehicle, if there's some reason to arrest an individual that's in a car, the search of the trunk is usually not included. I mean, they can still do it with an inventory search if they seize your car, but it's always a good idea to put things like that in the trunk. Some people have hatchbacks and or SUVs where the trunk area isn't necessarily separate, it's still a good idea to put it back in the rear of the car, in my opinion. So it's not immediately accessible to the driver or passengers. It's not a good idea to keep it in the glove compartment, center console, under the seat, et cetera, et cetera. Okay, so let's say you get stopped by the police. What are you going to do? What should you do? Well, I would say the first rule is to behave politely, right? I mean, I'm sure most people have seen that Chris Rock video, right, where he talks about things not to do when you get pulled over by the police. And I think he's with a lady, and she's screaming, he's got weed," and Chris gets yanked out of the car and beaten by the police. I mean, of course, it's comedy, but it it it, there was another scenario where I think he's with a friend who's crazy, and the guy verbally abuses the police, and then they both get beat up. So yeah, it's always a good idea to be polite with police and not pull an attitude. If you're asked, it's always a good idea to ask if you're free to leave. Anytime an officer hears that, I think they're going to wise up and know that at least you have some understanding of what your rights are as an individual. If you're not free to leave, you're under arrest. That's what it means. And if you are free to leave, but the officer says, "Hey, yeah, I've given you this ticket. You're free to leave, but I'd really like you to stick around because I've got a dog coming. We just want to, I'm sure you're not hiding anything. We just want to check your car." No, you don't have to stick around. Bye, Felicia. We're done. Leave as soon as you can. Of course, you don't want to flee from the police. You want to make sure that you're free to leave when you do that. I can't tell you how important it is to remember to keep your mouth shut. You should not volunteer information. You should not provide information at all other than what your name is. And, you don't have to answer questions. Miranda warnings, everybody believes that, oh, they can't use that. They didn't give me my Miranda warnings. Usually they're going to give you Miranda warnings once you're arrested. They're not going to give you Miranda warnings usually when you are pulled over in a traffic stop, because under Fourth Amendment law, that's not really considered a private place. It's open to other people driving by. And so the coercion that could take place inside a police station, where coercion is at its highest, and why the Miranda rule actually came into effect, it's really about custodial interrogation and station house questioning more than it is about roadside questioning at a traffic stop. So Miranda is not really going to work if you get pulled over with your car at the site of where it's been pulled over. So yeah, you should offer your driver's license if they ask for it, insurance card, etc. But keep the conversation to a minimum. And I will tell you that sometimes people, the officers, when everything seems to be going pretty well, you're only going to get a warning, but they're engaging you in conversation to get more facts to determine whether or not they have probable cause to believe that maybe you're doing something. And sometimes it's just to eat up the clock so that they can have another car pull up with a dog, and they can do what they call a free air sniff, because the Constitution holds that if a dog goes around your car, that's really not a search, because you're not entitled to have anything that's illegal. And if you have drugs that are illegal, then you never really had the right to have it in the first place. So a dog can sniff for it, and it's free. I'll talk about this a little bit later, but the smell of marijuana has become a very large issue in criminal defense practice. And the issue has not yet been resolved by the Illinois Supreme Court, as it has in a few other states where it has been legalized. So here's a few quirks in the law that you should know. And I talked about this. Dispensaries cannot keep a record of their customers. But compare that to medical card holders, where real-time tracking of the date of sale, the amount, the price of medical cannabis purchased by a registered qualifying patient is recorded. So the limit on how much you can purchase is only imposed at each purchase. You could, like I said, theoretically buy an ounce a day, every day, etc. But you're only entitled to have it 30 at a time on your person. Now, if you're arrested for having over 30, so let's say you bought 30 and you kept it in the car, and now you went, you bought another 30 and you got pulled over and they found 60 grams. Well, you're only allowed to have 30. Guess what you're going to get charged with? 30 grams? No, you're going to get charged with 60 because the law does not subtract the legal amount from the whole. And, there was some effort to change the law because these cannabis cases haven't really gone that far in the appellate court. With 2 years of COVID, a lot of litigation didn't take place in the courts. And it usually takes a few years for a case to rise through the procedure, through the appeals process, to the point where opinion is actually published. And so some of those opinions are coming out, but there are some splits in authority. So back to the amount, 30 grams. There was some effort made to change that law, but that, along with the smell of marijuana constituting probable cause, those issues were debated and talked about at the General Assembly, but as of yet, they did not pass. There's one that I think is relevant to this discussion, and that is the law that Alexi Janulius, the new Secretary of State, fostered, which was removing the statute which made it illegal to have something hanging from your rearview mirror. That was used routinely by troopers to pull people over on I-80 and then eventually do searches of their vehicles with dogs to find narcotics, marijuana, cannabis, etc. And so it was completely pretextual in so many ways. And that no longer is the law. I mean, I had a client who was charged with cannabis trafficking, and he was traveling at speed limit, but he had a handicap placard that was hanging. And he got pulled over. He got, why don't you come back here? I'm just going to give you a warning. Hey, where are you coming from? Oh, California. Yeah, what are you doing out there? Oh, we're just out on vacation. Yeah, when did you leave? Oh, 3 days ago. Boom. Makes no sense for somebody to be driving from where he was, Ohio, to California and then back in 3 days. Nobody does vacation like that. Guess what he just gave them? Probable cause. He just gave them probable cause to have a dog. And, within 12 minutes of that car being pulled over for that handicap placard, the dogs were barking, and the packages of cannabis bundled from Medford, Oregon, or wherever they came from, were located and seized. And he was arrested, and he wound up doing some prison time on it because it happened downstate, not up here in Cook County. And you should also know that the law requires packaging that is odor proof. And I think most people know that when they walk into a dispensary, especially in Illinois, where items are prepackaged before they go to that point of sale, that it still smells like cannabis. There's still an odor of cannabis. And the reason is that despite the packaging, despite the heat sealing, despite all of that stuff, it still has a fairly pungent odor that can be smelled by, if not humans, then at least animals like dogs who are trained to locate cannabis, whose noses are just so much more sensitive than a human nose. And there are actually opinions from appellate courts that have said, well, if the dog smelled it, then of course it wasn't in an odor-proof container. So there was also a movement afoot to remove the odor-proof language from the statute. That also stalled in the spring session. Maybe these will come back in the fall veto session, but it seems that the legislators are taking a wait-and-see approach with what the Supreme Court does, because the smell of marijuana issue is before the Illinois Supreme Court. Ooh, that smell, right? Under current law, cannabis has to be in an odor-proof container, and there's the citation for that. It's under the Illinois Vehicle Code. And there's a split in the appellate court districts on whether the smell of burnt or raw cannabis is enough for probable cause to search a vehicle. Now, the Illinois Supreme Court, like I said, is the issue is still being briefed. In fact, today there was some discussion within the Illinois Association of Criminal Defense Lawyers about backing a couple of amicus briefs, or maybe writing our own brief along with the ACLU about this issue, because it affects Black and brown communities quite a bit. They get pulled over more for things like, hey, your car smells like weed, than frankly people like myself or maybe people on the North Shore do. And I mean, that's obviously a big sweeping generalization, but that's the concern. And so the two cases, Stribling and Molina, have been combined, and the Supreme Court will weigh in at some point, although I'm not sure when that's going to occur. And as I mentioned, the General Assembly took a pass on it. They're going to think about this stuff, and maybe it'll be resurrected during the fall veto session. So here's a quick little chart to show you some of the penalties. These are the penalties for straight possession. So when we say possession, we mean possession without that indicia of, hey, this guy's a dealer, you know, like without packaging equipment and without scales and without currency. You know, it used to be in the old days, pagers and cell phones, you know, pagers. Who the hell has pagers anymore? It's all cell phones. Everyone's got a cell phone, but straight possession we're talking about. So if you have more than 30 grams, right, it's a class A misdemeanor that carries up to 1 year in jail. Possession of 100 grams to 500 grams is a class 4 felony. You can get probation for that, but it technically carries up to 3 years in prison. And a class 3 felony carrying 2 to 5 in prison is if you've got between 500 grams and 2,000 grams. 2,000 grams to 5,000 is 3 to 7 in prison, a class 2 felony. And more than 5,000 grams is a class 1 felony that carries 4 to 15. Now, if you are dealing it, or if you're growing it, or if you've got all that other indicia of, selling it, that offense is usually combined into something called manufacture, delivery, possession with intent. They'll all carry the same class of offense. They all carry the same penalty, which is usually bumped up from straight possession. So now, if you've got only 2.5 to 10 grams of marijuana, but let's say you're caught selling it, that's a class A misdemeanor. Between 10 and 30 grams of cannabis is a class 4 felony. And I had a college student recently who got arrested with 120 grams. He was going back for the semester. He had saved up money the entire summer, and he had $5,000 in a cash box from bartending at a bar all summer. So the police put a dog on his car because he had stopped at a rest area. And he walked into the rest area. The rest area had been put up right before this concert that takes place in Southern Illinois, in Chillicothe. And he had stopped at this rest area. There was a sign that said, it was a drug checkpoint ahead. with a squad car that was parked there. So this is sort of a roof checkpoint that gets set up by sheriffs sometimes, not the state police. These are local sheriffs throughout Illinois, and they'll set up these roadblocks, and people who are carrying sometimes will obviously try to get rid of their stuff at the rest area. So my client in that case parked the car and went to the rest area, but they thought that he was looking around, so they just put a dog on his car, and it alerted, and they got his keys, and they searched the car, and they got 120 grams from his car trunk. So the state's attorney's there because in his questioning he said, "Yeah, once in a while I'll sell a quarter to my my roommate, if he's in, but I don't like take a profit on that. I'll sell to him for cost." They charged him with a class 3 of manufactured delivery possession with intent of 30 to 500 grams, a class 3 felony, and you can't even get probation for it. You can't get expungible probation. So this would be a college student who'd have a felony on his record if he was convicted. We put up a big fight, and on the day of jury selection, they reduced it and offered expungible probation, and the client took it. That was a happy ending. They don't always end up with a happy ending because you still expose yourself to this kind of consequence when you carry that kind of those kinds of amounts. Now, also, because cannabis is legal, people think that you can drive around. You can drive around with cannabis in your system. Before, it used to be sort of a strict liability offense if anything happened while you had cannabis in your system. Now, at least, there is a requirement that there be at least 5 nanograms or more in whole blood or 10 nanograms or more in a bodily substance. I'm not a big DUI lawyer, but, basically with implied consent laws and DUI, you are offered to take these tests. If you don't take them, then your license is suspended for 12 months. Whereas if you do take the test and fail, your license is suspended for 6 months. So, these are statutory summary suspensions. It's sort of a niche area of practice for traffic lawyers to reinstate people's driver's licenses. This is something that's done usually before administrative hearing officers, many of whom are former DUI lawyers or lawyers for the Secretary of State. Not everybody does this kind of stuff, and a few people do it really well. Hey, I'm at the end of my presentation. So that's what I got for you guys. If you have more info, that's my phone number. And there's a chat in here. And
yeah, so I just wanted to remind everybody, if you want, I will grab this the PowerPoint, and I will post a link to it. I will also post a link to the audio to this as well. I'll send it out to everybody. At the top of the hour, Bob had talked a little bit about Megan's Law. I put a link in the chat to an interview that we did with Megan's parents that kind of talks about their process of getting that law enacted. I think it's a great story, and it's well worth reading. Bob, do we have a few minutes for questions?
Absolutely, yes.
Excellent. So if anybody has any, actually, I'd like to ask a question, if I may, to get the ball rolling.
Sure.
So in terms of the law, the current law regarding the actual amount seized versus the amount that is allowed currently by law, the process. So you're on the team that was trying to get that repealed or get that enacted.
Yeah. So what you do is there's various ways to do it, right? You can call up your state rep or state senator and say, "Hey, this is a big important issue. I want to talk to you about it." But there's also other ways to go about it. I sit on a section council of the Illinois State Bar Association. So the State Bar Association has a legislative committee that usually every year will ask lawyers what do you think should be changed in the law? So in the Criminal Justice Committee, I asked them, I proposed this change in the law and I wrote it up. And so they worked with it, and ISBA Legislative Affairs shopped it around and found a couple of legislators who were advancing it, but it did not gain uh, the kind of support. And plus, there was another state senator, Senator Ventura from the Joliet area. She also had her own bill, and that kind of took, um, that was also saying that uh, the smell of cannabis alone is insufficient for probable cause. So, you have to have something other than just the smell to start searching people's cars. Um, However, like I said, there was a lot of resistance to some of these changes, and some of that resistance, of course, comes from law enforcement, and some of it comes from interests that want to see the court adjudicate this issue, i.e., the Supreme Court, where the issue is pending, before the legislature speaks on it. And which brings up a much bigger issue, I think, which is who really makes the laws? I mean, do the legislators tell you what should be probable cause, or should the judiciary be telling you what's probable cause? I think they both kind of do it. And sometimes it becomes, for lack of a better word, a pissing contest between them. Did that answer your question, John?
Yeah, no, it's helpful. So Cole has a question. Cole, if you can unmute if you'd like.
Yeah, can you hear me? I just changed my microphone.
Yes, absolutely.
Yeah. Sounds good.
Perfect. Hey Bob, thanks again for your time. I had just a few questions for you that kind of were inspired by your presentation, and also just as a consumer trying to better understand the law. So you had, I believe, on slide 7, how to transport adult use cannabis. Do you have any recommendations on how medical cannabis patients should transport their homegrown cannabis?
Yeah. Because they have a medical card, that should be great. But I think they should try to use containers that look similar to the ones that dispensaries use. So, the plastic sealable glass jars, things like that. And I think they should also put them in their trunks, or, obviously not close to them, not on the passenger seat, not within arm's reach, preferably not in the interior passenger compartment of the car, somewhere in the back.
Awesome. Thanks. And in the same vein of homegrown cannabis, I was wondering if you could give me your legal understanding of medical cannabis patients' possession limits at home as it relates to homegrown cannabis. I'm under the impression that Illinois is what some call a quote, keep what you grow state. And some attorneys have even pointed me towards the possession language in the law, which says that for registered qualifying patients, any cannabis produced by cannabis plants grown under subsection B, blah, 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 provided any amount of cannabis produced in excess of 30 grams of raw cannabis must remain secured. So I've even asked the state about this, and they answered and said they interpret it the way that I've interpreted it, but they stressed that it wasn't legal advice. And again, I kind of wanted to ask your legal advice. Have you heard anything in this, or have you had any experience with possession limits as they relate to homegrown cannabis?
I haven't had a case on it, but intuitively, what I would think is that what they're concerned about is people who are growing more than what they need and then trying to sell it for, on a secondary market for a little extra income. That's probably what they're trying to avoid. So if you grow extra, yeah, you can have it, but you got to keep it and you got to use it and you got to have it at your own place. Don't, I think that's probably what the motivation behind that law was.
Yeah. And I guess my question there was, I'm sorry, I kind of got long-winded. Are you aware of it, or do you interpret it to be the same thing? Whereas, as long as you're being careful and, like you say, not doing those things, selling it, that you can keep everything that you grow. You don't necessarily have to throw out any amounts that exceed 2.5 ounces, right?
Yeah, I mean, your own production is not limited to possessing. That's more for the medical card and going out and getting it at the
Sure. Purchasing
of that. Yeah, it's sort of like an extra having these 5 plants. Like I said earlier, it's not that easy to grow 5 plants and have a harvest. I mean, it requires a lot of work. So more power to the people out there who know how to do that properly.
Yeah,
All
absolutely.
right,
Yeah,
excellent.
thank you. Thank you
Excellent.
for the time, John and Attorney Galhotra.
Thank you. All right, now JD has a question.
Yeah, and thank you so much, Bob, for taking us through this. And it's crazy because I feel like everything's changing, the laws are changing, and it's so hard to keep up on this, especially with each state continuing to change their laws as far as travel. Talk to me a little bit about where you see things going, because I'm curious. I always love looking into that crystal ball as we look in the next year to 2 years. How do you see things changing, and things in motion to change as far as it comes to transporting?
Yeah, so a big part of transporting from a legal point of view is that odor-proof container stuff, because the odor-proof container is what provides the entree for the police to do a search and find other things. And that's usually when a criminal defense lawyer gets involved, because sometimes other things pop up that maybe you don't want to have pop up. But sometimes it's just additional cannabis too. But let's get to the bottom line. Sometimes it's just them searching your car and finding nothing, and they just wasted a half an hour of your time. Why? Because you were a legal purchaser of cannabis. And think about all the people that are out there who legally purchase cannabis. It basically gives carte blanche to search any of their vehicles because it's not in an odor-proof container and because a drug dog can sniff it. So I don't know what the Illinois Supreme Court is going to do. I think the Illinois Supreme Court is a little bit more conservative than many people give it credit for, but I think the General Assembly is a little bit more progressive than the Illinois Supreme Court. So if the Illinois Supreme Court's decision is not favorable, I do foresee legislation that will go into effect in January that will eliminate the odor-proof language and also remove the smell of cannabis as probable cause solely for a search, or that will require more than just the smell of cannabis. So I'm hopeful, and I'm thinking that if the court doesn't do it, the legislature will.
And then in that same regard, as we continue to face challenges on a federal level, where do you see changes going there?
Boy, it's just so disappointing that on the federal level, it has not been addressed yet. But there are still many states who vehemently oppose legalization, and this is, it is. I'm sure David can explain political theory a little bit more about the United States a little bit better than I can. But this is a republic, and this is that's sort of the way the country was set up, where the states would still have their sovereignty. I mean, I don't know. David, I know, has a question. Maybe he can give us a little comment about that as well.
And by the way, thank you so much, Bob, for your insight. And I'll kind of turn it over to David, although he says JD has my question withdrawal. But
well,
David, to add there?
I was just wondering if there was any knowledge from the, our federal representatives, if they are at all, if not looking towards positive legalization, at least descheduling cannabis as a narcotic on the same level as fentanyl. Have we heard anything from our elected officials that visit Washington? I guess that would be my follow-up to JD's questions. And thank you for presenting tonight.
Well, yeah, I'm not sure what the feds are doing. Obviously, there's two aspects to it that everyone's concerned about. One is banking, right? One is being able to take the, you know, to actually take the money from cannabis sales and put them into a regular bank and not have to, you know, charge cash and be able to do credit card transactions, et cetera, et cetera. So there's that aspect. But yes, definitely, it's the scheduling aspect too, and removing it from a Schedule A narcotic with the kind of abuse potential as heroin or anything else. I think it's even, yeah, or fentanyl. Um, I don't know to what extent the Judiciary Committee in Congress, the Senate Judiciary Committee is responsible for this. And you know, there has been sort of gridlock due to some of the senators not being available and not, you know, leading the committees through some of the work that they have to do. So I'm not sure if that has something to do with it, but I mean, eventually we'll get there. I just can't predict when that's going to be. I wish I had a better answer.
All right.
Let's see. Is there?
Let's see.
It sounds like you're optimistic that the issue of odor will be addressed in another. Yeah. Do you have the same optimism on possession limits? And yeah, that's a good question, Cole. I don't think so. I don't think it's going more than 30 grams. I really don't.
Yeah, I think that's going to be at the end of the day, from at least from what I'm hearing, that will be, you know, I think the major brands will put a kibosh because they want to keep people coming into the stores.
Yeah, I think it would be against their profit motive to allow larger amounts to be possessed, because I think that would then fuel the black market even that much more. Because, you know, if people are doing it now with impunity, just imagine if there were more generous limits on what you could carry. Yeah.
Well, listen, Bob, thank you so much for your time. We're coming up on an hour. Thank you so much, everybody, for joining us. We greatly appreciate it. Like I said, I'll be sending out sometime tomorrow. I'll be sending out all the rigmarole from today. But like I said, Bob, thank you once again. If you want to get in touch with Bob, it's Galhotra Law, and we'll send out links with the email. So once again, Bob, great job. Folks, thanks for joining and have a wonderful, wonderful weekend.
Thanks. Bye-bye.
All right.
Thanks. Take care.